were injured in a car accident and you believe that you might have some responsibility in causing the accident, are you still entitled to receive compensation for your injuries? Hi, I'm Guy DiMartino. I am a Northwest Indiana personal injury lawyer, and I would like to answer that question for you because it recently was asked of me. So, this is the fact scenario. Maybe you're driving down the road and maybe you stopped a little too quickly or a little too short, and you feel that maybe you didn't give the person behind you enough time to stop, so you might have some culpability in the accident. However, you had pretty severe injuries. You broke an arm, or you broke a leg, or you broke your sternum, or you broke your clavicle, and you still want, you lost work, you have all these medical expenses, and you still want to be able to know if you can receive compensation because you believe the other person was not paying attention, and if they were paying attention, they would have been able to stop. The answer to the question depends upon how much a jury or a judge or an insurance adjuster believes you are at fault. And this is what I mean. Indiana is what we call a modified comparative fault state. So what that says is, let's look at the parties and let's look at you as the injured person, the one who's bringing the claim. And in Indiana, you can receive compensation for your injuries as long as you were not more at fault than the other driver. So, if you're both 50% at fault, you can receive compensation. However, if you're 60% at fault for the accident, then the compensation is a big fat zero. So, this is the way it works. Say you get a $100,000 verdict, and a jury says that you are 20% responsible for the accident. The $100,000 will be reduced by your comparative fault, so it'll be reduced by $20,000, and the net verdict would be $80,000. Same thing if it's a 50-50 case. If the jury says, I really can't determine, I'm going to assign 50% at fault to you, 50% at fault to the other driver, your $100,000 verdict would be reduced by 50% to $50,000. On the other hand, if the jury should say that you were 51% at fault, you're not going to get 49 grand, you're going to get zero because you were more at fault than the other driver. If you have any questions about this idea of comparative fault, you can always reach out to me. I am Guy DiMartino, meeting you at the intersection of law and medicine. Have a great day.